Good afternoon, everyone.
Good afternoon.
My name's James Conduit. I'm a corporate and commercial solicitor at Sills Betteridge solicitors. We have offices throughout the county into South Yorkshire, Nottingham and Northampton. And my work is predominantly buying and selling companies. Most business owners have a plan, and if you don't have a plan, you should do. Now, whether that's to build up your business over the next 5 or 10 years, whether it's to retire at 55 and spend the rest of your life on the golf course, whatever it is, you need to think about how you're going to achieve that and what are the sorts of considerations that you need to have now in order to get to that end point. There are broadly two categories of exit. There's the managed exit, where everything goes according to plan, and then there is the unexpected and unanticipated eventualities. I'm going to concentrate on the managed exit today, but I do have a couple of points to make about the unexpected, and we'll come along to that in just a moment. In terms of a managed exit, it rather depends on the type of business that you've got, and you're not always going to know at the outset as to what that sort of end goal is going to be like. It might be a sale to a third party, and some businesses lend themselves very well to a sale to a third party. But if your industry is particularly niche, or it depends very much on you, the individual, then a sale to a third party probably isn't going to be the end goal. A management buyout is a potential option where you have some trusted management in place, and over time you train them up in every aspect of the business, and you ultimately sell to the management team. That can be a very smooth process because they're not going to have the same level of due diligence into your company as a sale to a third party. A third party doesn't know anything about your business, any of the skeletons in the closet. The management team is going to be much more knowledgeable about the business, and you're going to have a lot less to be concerned about when it comes to giving what are called warranties and indemnities, and we'll come on to that in a moment. Listing, obviously, if your business is on the verge of being listed on any of the major markets, then you're probably not going to be here listening to me. But it'd be remiss of me not to at least put it on there as something that if you've got a business that's building very rapidly, that might be an option for you at some point in the future. Passing the business on to a family members is also sort of akin to a management buyout, but the terms might be a lot softer, and they are probably less likely to ask for warranties and indemnities from you, particularly if you're being benevolent and giving them some of the business and allowing them to run with it. And then lastly, on here we've got employee ownership trusts, which is more along the lines of the John Lewis style model, where employees have a stake in the company. That is an area that is steadily growing. They've been around for a long while, but they have very favourable tax treatment on realisation of value for business owners. And so that is an area where I think we're going to see a lot of growth as time goes on. Which leads me on to my next slide. I'm not going to spend too much time on this, but many of you may be familiar with the term entrepreneurs relief. It's been around with us since the days of Gordon Brown's government, introduced by Alistair Darling in 2008, essentially to compensate for the removal of a previous relief. And it initially started as a reduced rate of 10% tax on capital gains. So you start your business with nothing. The shares in your business, when you incorporate them, are worth the £100 that you pay for them, and then you build your business up over 10 years, and all of a sudden those shares are worth £1 million. You could get that money out at a 10% tax rate. Then 2010, the limits increased to 2 million. Then later in 2010, once the Conservative and Liberal Democrat coalition came in, the limit was of lifetime gains was increased to 5 million, then to 10 million, and then everyone realised it was a really bad relief. And it didn't serve any of the purposes that it was designed to. It didn't really encourage business owners to do anything other than to enjoy the relief whilst it lasted. And since, well, certainly as long as I've been practicing, there's always been the fear that entrepreneurs relief, which is now called business asset disposal relief, might be removed. And so before every single budget, company accountants and corporate lawyers get very excited, and we get a massive flurry of work as people think that it's going to be removed. 2020, the lifetime limit was decreased from 10 million to 1 million and renamed from Entrepreneurs Relief to Business Asset Disposal Relief, known as BAD Relief. What I would say is it isn't going to last. We've been saying it for years, but I think now it really is going to disappear. In the committee stages of the finance bill for 2020, when they reduced the limit and renamed it, the MP who was speaking for the government at the time said, "The honourable member for Aberdeen South was absolutely right to raise the extent to which this was known to be a bad relief." He didn't even say no pun intended. He then goes on to say, "I am sympathetic to the point that the Honourable Member for Horton and Sunderland South makes about a more structured approach to the analysis of tax reliefs. That point is well made." Essentially, the Entrepreneurs Relief never fulfilled its promise as encouraging entrepreneurs. My answer to her comments about the IFS's concerns about the residual relief is that there is always scope for further reform at future fiscal events, which is effectively sounding the death knell for business asset disposal relief. So that 10% tax relief is going to go. I think that we can be very confident of that. When it goes is anyone's guess. But it seems to me that on both sides of the House there is a will to see it gone, which means that then the potential tax gains from an employee ownership trust, where you can potentially get money from the sale of your business to an employee ownership trust without paying any capital gains tax at all. So that is probably where we're headed. The unexpected early exit, I said I was just going to touch upon it. Death, obviously, let's not dwell on that. Incapacity, these are two things that you do need to plan for, certainly, and probably the greater concern is incapacity. If you have a limited company and it was incorporated after a certain date in 2009, death is not so much of a problem in terms of a company law procedural issues. There used to be a problem. It got resolved in 2009 with updated Articles of Association, which all new companies are now incorporated with, or virtually all of them. But incapacity is still a problem. And if you are at the helm of a company and then you become incapacitated, it can be very, very difficult to actually operate the company, and so you do need to have an idea as to how you are going to deal with that. Insolvency, I'm not going to touch upon at all, other than to say take advice early. The sooner you speak to an insolvency practitioner, insolvency solicitor about potential issues that you might have on the horizon, the more they can do to assist. Okay, so when we're talking about selling a company, there are certain things that are common to all business sales, and knowledge of that well in advance allows you to order your affairs in a way that if you do have a third-party purchaser come along, they can look at your company and you can say, hand on heart, there is nothing wrong with my company. We have got all of the little bits of paper that we need to prove that we are compliant in every respect. Businesses are different across sectors, but there's a lot of commonalities across them as well. In terms of the structure of a business sale, heads of terms, you agree the general commercial terms, but at that stage you also put some lines in the sand that can be important and can come back and bite you. I have a transaction on at the moment, I won't name any names, but my client, who is well versed in buying and selling companies, I would add, signed some heads of terms which he didn't really read, and although as he did, he came to me and said, well, they're not legally binding. No, they're not legally binding. Generally, but they do act as a moral compass to the transaction, and it becomes very difficult to row back from something that you've agreed in principle at a commercial stage. And his heads of terms included a personal guarantee, personally guaranteeing the sale of shares in a subsidiary company, which he's going to have to work out what he's going to do with. But let's not spend too much time on that. But heads of terms, getting advice early on, just querying, is that normal? Does that present any problems for me? Is well worth looking at. Non-disclosure agreement, you do not want to be saying, here's a long list of all of my key customers to someone who's potentially a competitor looking to buy your business. You need to have some sort of protection in there so that you do not disclose anything which could then be used in competition against you if the transaction falls through. Then there is a process called due diligence. So if you are buying a company, you don't know anything about it, the old adage of buyer beware applies. You need to ask some questions. You don't buy a car without asking some questions. You certainly don't buy a company without asking some questions, because there could be all sorts of potential liabilities in there. So a buyer is going to be asking for a lot of information. And the answers to that due diligence process will inform what they think about the potential risks in the company. If they ask you, please can I have anonymised copies of all of the contracts of employment, and you are not able to provide copies of contracts of employment, they're going to start to ask questions. Where else are they not compliant? If you're not able to provide details of insurance and an accident book, if you, particularly if you work in an area where health and safety is a key concern, any RIDDOR reports are things that often get asked for, and near-miss reports. If you're not able to provide this information, then they are going to start asking questions, and we'll come on to what the outcome of that might be later on. Share purchase agreement or business transfer agreement. Obviously, if you're running your business as a sole trader or a partnership, you're just going to be selling business and assets. But if you operate through a limited company, there's the choice. You either sell the shares in the company or you sell the business of the company. Generally speaking, you as a seller are going to favour the sale of shares. It's going to be probably more tax efficient for you. But a buyer may want to buy just the business and assets, particularly if at the due diligence stage they've highlighted some potential nightmare problems in the company, and they say, well, I don't want any of that. I'll take all of the good stuff and you just keep all of the potential liabilities. Payment terms. As a seller, you're going to want to have as much cash as possible on completion. The less that is left outstanding, the better. Earnouts, very popular at the moment, and certainly in certain sectors where a management team may be selling the company to a big corporate, and they get the opportunity to earn a bit more money if the business does well over the next 2, 3, 4, 5 years. Warranties. So this is related to due diligence. Your warranties in either a share purchase agreement or a business transfer agreement are statements about the company which you say are true. And I've just got a couple here just to highlight the sorts of things. This is from a short form agreement, but they are statements such as, the company has obtained all rights from third parties that are necessary to enable its exclusive and unrestricted use of the IT systems. So you can't be using an IT system if you don't have the rights necessary to do it. Compliance and consents. The company has at all times conducted its business in accordance with and has acted in compliance with all applicable laws and regulations. Now, sometimes these statements aren't true. And so we come on to a disclosure letter. The disclosure letter is your opportunity as a seller to say, these are all of the things that aren't quite right about my company. I wasn't always compliant with this particular aspect. And so you might make a disclosure about something so that they can't sue you for breach of warranty. The downside with that, of the disclosure letter, is the next item. So there's a warranty in the agreement that says we've always complied with all laws and regulations. Apart from that time when we never used to keep an accident book, disclosure letter, between the period of 2021 to 2022, we didn't keep an accident book and we didn't log any accidents, so we weren't compliant. So the buyer says, okay, that's fine, but we want an indemnity from you, that if it turns out that there's any liability associated with this, perhaps because you've invalidated your insurance because you've not been compliant, or whatever it is, we want to come after you for all of our losses. Absolutely everything that we suffer as a result of that non-compliance. So this is why it's important. We go back right to where we are now, of having a look at your company and thinking, what are the key areas where I might be non-compliant, and who, a third party looking at this, what might they be concerned about if they look at it and don't find what they're looking for. Because warranties, warranty claims are fairly unusual. Indemnity claims, in fairness, are fairly unusual. But the indemnities are the ones that keep you up at night. Warranties, you can limit your liability. You can, in the share purchase agreement or business transfer agreement, you can reduce the scope to which they apply. You can apply financial limits to it. Indemnities are the horror stories where if the liability comes in, you're just handing them your wallet and saying, there you go, you take all of your losses from that. Limits of liability and retentions. So if there are any potential warranty claims, you want to limit your liability as much as you can. Retentions, we'll come on to that in just a moment. But if the buyer identifies an issue in the company and assesses it, well, it could cost as much as £100,000, that we're going to withhold that money until we know whether that liability has come in, or we're going to withhold that money until you ensured that just to make a reference to a transaction that we've recently had, there was a piece of unregistered land that was always treated as part of the company property, but they had no evidence to establish that it was part of company property. So the buyer says, well, we're going to hold back whatever it is, £50,000 on account of that, and you go and get it registered. But if you don't get it registered, we keep the money. And so retentions are a fairly common way of dealing with these potential issues. Restrictive covenants, buyer doesn't want to buy the company and then realise that you've started up in business in competition the day afterwards. And you often have, almost always, on a share purchase, would have a tax covenant. And a tax covenant essentially says that everything up until the point that you sell your business, you will meet the tax consequences of that. So if you have underpaid corporation tax, that falls on you as the seller. It's a complicated document because tax is complicated, but in principle, all you're saying is we'll be liable for any reduction in value on account of tax up until the point of completion. So looking now at your business, you want to identify where is the value, because that's that's the part that a buyer is going to be most interested in. Is it in your property and fixed assets? In which case, are you ensuring that you're maintaining it all properly and you've got a clear record of maintaining it? Is it in the contracts that you have with your customers? If it is, then it can't just be on the back of a fag packet and a handshake. You need to actually have something that you can sell to someone, because a buyer is going to come in and say, well, where is your contract? How do I know that this person that's been doing business with you for the last 30 years is going to carry on doing business with me after completion? Now, it doesn't necessarily need to be a long-term contract, but it needs to give a buyer at least some reassurance that they will at least get their feet under the table during that transitional period. If it's goodwill, think about how can we protect our goodwill? Do we need to register a trademark if we're relying in particular on a trading name? Intellectual property. I deal a lot with software developers. And one of the concerns of a buyer of a company that generates a lot of content or a lot of software is copyright infringement, and ensuring that any libraries that you are using in the software that you write are fully documented, so that when they ask the question, what third-party materials do you rely on? You can say, well, I use all of these particular libraries, software libraries, and they are released under an MIT license, which anyone can use, and you've got a full register of everything, so that the buyer has that reassurance that you've got the rights to sell what you're selling. Protection of confidential information, particularly if you're doing a lot of if you have a broad client base, so for example, if you are selling IT services or print services and you've got customer lists, you want to have fairly robust confidentiality agreements in place with your employees so that they don't just take your book of customers to someone else because they don't like the look of the third-party purchaser. And similarly, restrictive covenants. If you're in that type of an industry where you've got a large customer base entrusted to your employees, you need to have restrictive covenants in a contract of employment with them so that they just don't set up shop the moment a buyer comes in. And the other side of that, the other thing that a buyer is going to be looking at are the risks associated with, with businesses in general, but also in the business in which the sector in which you operate. So contracts, limits of liability. If you work in an area where you're supplying services or goods, you may expose yourself to potential liabilities if your customer injures themselves or relies. So, for example, we're in Lincolnshire. You are a supplier of fertiliser and you supply fertiliser to a load of farmers and it doesn't work and a load of crops fail. And the farmers might well come to you and sue you for their losses. But it's not just as bad as the crops in the ground that they've lost. They might have lost the contracts that they had with the supermarkets. They might have lost other potential sums that fall far beyond what you might have otherwise envisaged. You can reduce that potential liability in your contracts as a company that's supplying fertilizer, for example. So that's contract. Employment, again, most companies employ people. They should have employment contracts. There's a statutory duty to provide employment particulars. Regulatory requirements. Generally, the businesses that I deal with that operate in regulated sectors, financial services and the like, they're pretty hot on all of the bits of paper because they have to be to comply with their regulators. Environmental issues. Again, have a look at your business and see whether there are any environmental issues and what can you do about it. GDPR, again, it's a raft of bits of paper that you need to have, but the policies need to be there because these are statutory duties. Intellectual property. If you are generating a lot of content and you're putting a lot online, you need to be really hot on whether you have the right to use, in particular, photographs. The number of times I've had clients contact me and say, I've had this letter from Pick Rights, I think is one. Has anyone had a Pick Rights letter through? It's not uncommon for companies like Reuters or Alamy. They have very complex algorithms that crawl the internet and search for matches against their inventory of photographs, and if they find a match and they don't have a record of you having a license to use that image, they will employ a third-party company, often, as I say, Pick Rights, who will write you a very nasty letter and demand money from you for copyright infringement. And if you've done it quite a few times, the sums of money can rack up. The very worst scenario I had on this was someone received a letter from a big firm of solicitors. It's a national firm, but I think it was the Leeds or Sheffield office, demanding £20,000 for the use of a photograph for one of their clients. Fortunately, we settled it for £300, but these are real issues, and if you aren't keeping track of where you're getting your photographs from that you're publishing, then you're open to potential claims. And tax is also a potential issue. Buyers' approach to risks, price chipping. So they might say, well, there are some problems with this company. We're not saying no, but we're going to reduce the price. We're not as sure as we were that you've got all of the contracts and that we're going to retain all of the contracts. So we're going to reduce the price. Certainly it's going to slow down the transaction because you've got to deal with these things. You've got to negotiate, okay, well, what are we going to do about this problem that we found in the company? Demands for indemnities, retentions and deferring of payments, less favourable limits of liability. Well, we're not going to agree to a limit of liability if we know there's a potential issue that is going to be in excess of that. And in the worst case scenario, your buyer might just walk, because they might say, these guys, they don't know what they're doing, because they don't have all of the compliance stuff that we really need as a corporate with corporate social responsibility and the like. Unexpected early exit and incapacity. I said I wasn't going to spend too much time on that. Power of attorney usually provides for incapacity. Two types of lasting power of attorney. This is beyond my area of expertise, but this slide is a relic from something that one of my colleagues had. But there are two types of lasting power of attorney. There's health and welfare, I think, and finances. And you can have specific powers of attorney that deal with just your particular company, as opposed to all of your finances. I'm going to skip over options available in your will, but there certainly are a number of things that you can do to deal with your business in your will. I'm just conscious that am I overstepping my time? Couple of minutes, okay, fine. Other issues to consider in your will, choice of trustees and executors. So who do you want to actually be dealing with your business affairs? And there really needs to be a joined up approach. If you've got a business, particularly with shares in a company, and your will says, I gift all of my shares in X company to my children, for example, but you've got a business partner, well, your business partner might not agree to that. They might not want to be in business with your children. And what's more, company law doesn't really allow that, because if the only director that's left in the company is the surviving director, they aren't going to register the transfer of shares to your children if they're not happy about it. So you need to be thinking about these things together as to what realistically is going to happen, and then order your affairs accordingly. So complementary documents. Shareholders agreement. If you are in business with someone else, it's always worth having a shareholders agreement. There is very little in company law that deals with the breakdown of relationship between shareholders, and it is a lot easier to enforce a contractual right than it is to enforce any of the rights that exist in the Companies Act to deal with these sorts of issues. Shareholders agreements are also quite useful because they can deal with succession planning for unexpected events. Partnership agreement, similar to a shareholders agreement, but obviously governs a partnership. Articles of association are your constitutional documents, but they are public documents. So anything that you might want to agree with your other shareholders in respect of a company, that will become public unless you put it in a shareholders agreement. It'll become public if you put it in the Articles of Association. It is also easier to do a shareholders agreement because you don't have to file anything at Companies House. Life cover is also worth bearing in mind, planning for the unexpected, that there may well be a big gap in the company, and the company may suffer as a result of the loss of a key person, and so having life cover there can fill that gap, but it can also provide a fund for the ongoing shareholder or shareholders, the continuing shareholders, to buy out the estate of the deceased. Articles of Association, I'm not going to spend much time on this because I'm conscious that I'm running out of time here. But there is quite a lot that you can do with Articles of Association to enhance the value of the company for using various incentives for shareholder employees, growth shares, differential dividends and the like. Shareholders agreement, key terms, permitted transfers. So you will need to have a discussion if you're in business with other people as to who can you actually transfer shares to. And if you can transfer shares to your children under the shareholders agreement, your co-shareholder, your business partner, needs to be under an obligation to accept that transfer and to run with it. What we more often see is an option to purchase coupled with life cover. So you've got two shareholders, they've been in business together, something happens to one of them. The continuing shareholder doesn't want to be in business with the children, doesn't know that they have got any business acumen at all. The continuing shareholder may very well want to buy out the estate of the deceased shareholder, but wouldn't necessarily have the funds to do so. So having the option to be able to purchase and having life cover there to fund it always helps. And then drag along and tag along clauses. If you've got some minority shareholders, you wanted to incentivize some of the management team, you gave them 5% of the shares, 10% of the shares. If that third party purchaser comes along just at the time for retirement, when you're ready for it, you want to be able to force those minority shareholders to sell. And I won't review anything because I'm conscious that we're running out of time. So does anyone have any questions about any of that?